to authorize indebtedness of the $6 million, which obviously, if that's not done, or if it wasn't legal, we shouldn't be moving forward anyway. We contended that that was done in December of 2017 with our bond attorney, which is why we closed on the loan. Had you guys not approved or authorized the indebtedness, it could not have gone to the bond commission, we could not have closed on the loan, and we could not have drawn on it. But that was the first recommendation in the opinion. So what we did was, because the opinion came 7 o'clock the next day, we did our due diligence, thinking possibly some of it might have been accurate. So we followed up with the professionals involved in it and basically negated everything in it. A response was provided on June the 14th. And again, it was with consultation with the bond attorney who closed on the loan, who consistently says the funds are readily available. LDEQ says the funds are readily available, and they all know we've already drawn on the funds. We spoke with our financial advisor, again, trying to verify what could have possibly been mistaken, and of course, none of that occurred. The reference with regard to the advertisement, we contacted LDEQ. They provided copies of their LDEQ guidance and informed me that I would not find that requirement in their guidance because it is not required. And again, another validation that the process was handled correctly. They approved the bids and specs. They looked at the advertisement, and they must approve every action before moving forward. So what we did was try to see if any of that was valid. So if we needed to correct it, we could move forward. However, none of it was. When provided with information contradicting the information in the opinion, we didn't get a response. So, and then we get a lawsuit on June the 25th. I, as the president, was served with the lawsuit, who forwarded it on to all of you with a date to appear in court on Friday. Our legal advisors never acknowledged receiving it, did not communicate with us either before court or at court, reported filing an exception that we did not have copies of, and didn't get until today, right before the meeting. In the hearing also, there was a petition for intervention that was filed that day based on an informal hearing, which again, we as the client did not receive copies of those. At this point, there's some contradictions. There's some problems here. So if bidding is not the proper method, then no, we're not going to go out for bids. But if we are forced to, well, then we need to re-engage digital, because they've completed the bid phase of this project, and if they do it again, there's compensation. And then whatever we change has to go back to LDEQ for approval before we can move forward. The advertisement, the changes to the specs, and again, that entire process has to go for approval every step of the way. So that's where we are.
Okay. Did we have to change the specs since end of May?
Supposedly that we needed to add something in the advertisement about funds not being available, but again, funds are available. Okay. So DEQ is telling us, it's not in our guidance. You don't need to do that. You've had 3 loans through LDEQ, numerous projects. That is not a requirement of our office, nor is it a requirement for capital outlay, which is very similar with regard to receiving funding from the state.
Okay. Well, thank you. I'm sorry, Mr. Saraparu?
Yes, and as far as this council is concerned, we were given advice through legal that we're in violation of the state bid law. Is that correct? I'd like Mr. Green to come up and give us a oral report on that last email. We get tons of email back and forth from administration and legal. I just want to make sure I'm not lost in a shuffle.
Keith Green, Jr. with the District Attorney's Office. Which email are you referring to, Mrs. Saraparu?
Received an email about 3 weeks ago about you told us we were in violation of the state bid law if we did not put the water meters back out to bid again?
No, sir, I don't remember that. Are you referring to the legal opinion that we submitted?
Yes.
The legal opinion. The legal opinion said that the violation was with respect to requirement to inform bidders in the advertisement that monies for the project would not be readily available because it's being funded in part or in whole by federal funds or other funding sources.
No, I don't think that's the one that I saw.
That was it. Which tied to the readily available component, which is questionable. Obviously, we've spent the money, we have the money, we have access to the money. So it is readily available by every attorney, every bond attorney, every engineer, every previous engineer who's done projects with us, and some of you know it, and those funds are available. Two, in approving the advertisement, LDEQ approved it as it was and still contends that that statement does not belong in their advertisement. So the issue right now is, yes, y'all made a motion. Without all the information, y'all made a motion based on the information y'all received that day. The opinion came back and said the solicitation was wrong. So what is it? That we're not supposed to do a bid because, which was wrong too, but because it's a non-construction project. It is a public work project, and the definition of public work involves dealing with your facility infrastructure, and any project over $154,040 is a public work project. Again, the process was approved at the beginning, before we started, by LDEQ, the funding source and the source of the smart meters. So yes, bidding is an appropriate solicitation.
Mr. Snyder?
Yes. If I got $100 in the bank and I go put another $100 in the bank, and my receipt will say it would acknowledge my $200, but I only have available $100, readily available.
Mm-hmm.
It's depending on how you look at that term.
Right.
To me, readily available is I can go get it out of there right now. That's what readily available means to me. Now, it may mean something to you, it may mean something to you people over here, but according to that, you mentioned the fact that we used some of the money already, but there was no problem because there was no issue like this before. And you still have to requisite from the state. You have to approve it, then you go on issue the
Yeah,
check.
it's called a payout. I think we use the word requisition, but what it is a payout.
Let me finish. Okay? So to me, that's what that means. It don't mean that it's readily available. It means that, sure, I can get it, and it's there, it's mine, I've been approved, but I can't get it today. I might be able to get it tomorrow, but I can't get it today. Now, we were trying, I thought that what the district attorney is trying to do, make sure that we cover all the bases, Now, I like to ask this question. I don't know if I asked this question before. If these people who, we got sued from both ways here, if they wanted to sue us because of that, could they have did the same thing, put an injunction in there and stop us from going forward because the money is not readily available and we didn't say that? Could they have done that? Would they have grounds to do that?
They could have, but they know better.
I'm talking to the district. I'm talking to our legal people.
Well, I answered.
Yeah, that's wrong then.
No, it's right.
No, it's not.
They could have sued us.
You're always right. That's the problem.
That's probably it.
Yeah, that's exactly what it is.
Mr. Snyder, hang on a second. You're not going to speak until you've been recognized. Mr. Snyder has the time. Go ahead, sir.
And that's what I'm talking about, see? And that's why we got this issue right here, right now. We told you to do something. I don't know where you ain't got your legal stuff from. You might have got it from Aqua, you might have got it from Green Up, I don't know. But I know one thing, we know who is working in our best interest. That's who we know, and that's the kind of people we follow. Now, could you answer that for me, sir? Just give me some kind of, could they have grounds to put an injunction on there and stop this process because that didn't happen?
Yes, Mr. Snyder. In fact, under the public bid law, the public bid law allows any person or corporation or entity, for that matter, to file a civil action against any public entity who they allege has violated the public bid law. Now, that's a change from where it used to be only individuals who were aggrieved by the public bid law could file for injunctive relief only. But the legislature has since expanded that to allow any person or, like I said, corporation or public entity anywhere to be able to file a lawsuit for an alleged violation.
Okay. Now, none of this has been settled. We got an agenda coming up next week with all of this on there. Why? So why we haven't done this already? That's what now I'm asking the administration.
Okay.
Who told you not to go forward with it?
It's in your opinion. The opinion from the
opinion?
district attorney's office.
Not to go forward with
They
the
said that the
bids?
bid process was an incorrect solicitation process. That's listed in number 7 of your, therefore, we shouldn't have bid the project because it's a non-construction project.
Okay. Question is, after that, we gave another directive
No, sir.
you told me the directive that we gave.
Yeah,
That
the
was wrong?
you gave the
district attorney
direct-
told us not to do it?
Yes, sir.
Okay, then. Then we can't do it. If they told us not to do it after we gave you the directive.
After the motion was passed, you're right.
Now, everybody up here understand that?
Did y'all read
Ma'am?
it?
I'm confused also.
Okay.
Because my first time hearing about that.
Did y'all read the opinion?
Well, I read this, I read that, I read
Okay.
some of this, I read stuff from everybody in here.
Just for clarification.
lawyer.
The motion was made on the Tuesday night. We got the opinion the following day at 7 o'clock.
Okay.
When you went through the opinion, there were numbers of issues that were raised, none related to the initial
Okay,
cause.
so now, as far as the district attorney is concerned, we shouldn't be going out for bids.
That's what the opinion says.
Okay, that's what they said, the district attorney said that. That's fine. Now, next thing, I think we need to be talking about this Sam situation here. We've got to, you said we got to go through this whole process again. Can we get another engineering firm to do that? Can we? Because it looks like we just can't pick engineering firms. We had the same problem with the people with our storm money. Now we got a problem here again with this water meters.
Excuse me,
Because I think
Mr.
it's the
Mallett.
process we're using. Now, can we?
We don't have
that's
a
what we
problem.
talk-
Are you recognizing me or not?
Yes, go ahead.
Okay, I'm sorry. There's not a problem with the engineering firm. There's not a problem with the process. Again, the only opinion, which it's an opinion, that there's something wrong with the process is coming from Keith Green. Okay? Everybody else involved in the process with authority over the process, who's been involved in it for 2 years, contends the process was followed. It followed public bid law. Every step was approved by LDEQ with regard to the specs, the advertisement, the actual documents that came in as a result of the advertisement had to be reviewed. The budget was amended. They approved the amendment based on approval of Aquametric as the lowest responsible bidder. They contend, they stand by their concurrence, that the process was followed, that requirement to add that language in the advertisement is not a requirement. They provided copies of their guidance, and they contend the funds are readily available. Now, Mr. Snyder, I want to go back to your readily available, because we have money too. Okay, we award bids, we have money, we can't get it today. Like, if I want to get some money, and we have money.
You can get what's readily available today.
Like what? We don't keep money in the building.
I know that to tell me, when I put money in the bank,
Right.
this is readily available, this, you can't get this.
Okay,
What
well,
you
our
just-
money is
it could
readily
be
available.
cash.
If we send an app in, we could get our money. It's just like right now. If our attorneys give us an
Send it where?
invoice,
Send it to the bank? Or send it to someone else?
we send it
Till
to.
you approve it?
No, we send an application, send us our money. It's like
Send who? I'm saying who? Where you sending that?
we send it to LDEQ.
Oh, okay.
Okay, and it's a pay app. It's like, we have your money, this is your money, this is how much you need right now. The reason they keep it is so we're not dealing with interest-bearing accounts and all of that, but it's our money. If people work for us right now, we have bond money, that money's readily available. But if you send me an invoice, we have 30 days to give you the
that's
money.
bond
That doesn't
we
mean
got-
it's not readily
we got it in the
available.
bank. Yeah, I understand that.
Okay, well, this money is like in the bank. We just have to get it. with the pay app.
Except that my wife got to approve it. That's why I won't go get it. She got to approve it. And she said, no, then I don't get it. And it's ready available. Now, if it was my money, under Larry Snyder's, then I can go get it.
But again, if, for our processes, people submit requests for money, we do our due diligence. Just because you send it to us, don't mean we give it to you. It could be in my office. But when you send us an invoice, somebody has to sign off on it, verify the work was done. It goes through a process, they cut a check, they do, again, that doesn't mean your money's not readily available. That's just your internal process for dispersing it. Again, we have net 30, but that doesn't mean we don't have the money. We have all the bond money.
No.
Okay, but you don't get your money like the day you ask for
You
it.
should be a lawyer for one of these groups that's filing all these, because you show backing them up big time.
I'm on right, okay? The question is not
I
who
want
I'm
right here for
representing.
people.
You need to be worrying about who your attorney is representing, who still has not communicated with the person who was served with the lawsuit.
Who's that? Us? State, Parish? Ms. Rowbottom?
Mr. Mallett?
I'm finished, Mr. Mallett.
Laverne has a...
Yes, ma'am. No. Actually, Miss Councilwoman Gode is up next, and you'll be following her.
Thanks, and I asked Keith to get a printed copy of the opinion, because from my understanding of what the district attorney's opinion was, not that we couldn't do a bid process, but that for, I guess, the way that the project was classified, that maybe there was a more, I'm just kind of glancing through it right here.
That's not what it said.
It says the recommendations were that the parish council adopt a procurement process for the fair and transparent competitive selection and award of all public contracts, including but not limited to RFPs, RFQs, and uniform public bid law, and that the parish council duly passed a motion requiring mandatory professional development training in Louisiana public bid law. So these are some of the recommendations. I don't see in the recommendation, is it the next page you said?
It's actually on page 7, number 7.
That's where I am.
Number 7? Mm-hmm. Like next to the number 7?
I'm next to the number 7, where it says installation of water meters is not construction, and the Louisiana public bid law is not the proper solicitation method. The recommendations, it appears, are that we adopt the procurement process. So I guess the question, and I brought it up, I remember the motion you're talking about, I voted against it because I thought it would have been more appropriate to separate and hard bid the meters and use RFP for the service, the software component of it. So my question would be for legal, right, because if we authorized a motion that said that it was rebid, again, a motion I voted against, but nonetheless, a motion that was duly adopted by the council, is the district attorney's office saying that the project can't be rebid? Because then, right, we're saying to rebid something that the DA's office would say that we can't, or how do we remedy that part right there?
So basically, if you guys decided to do rebid, then of course, with respect to the DA's opinion, full compliance with the public bid law, specifically with respect to the readily available language. However, the council opted not to rebid, but to use some other solicitation method.
No, they voted to rebid.
Right, okay, so because they voted to rebid, then the only thing we were saying in our opinion is that if you rebid, then you have to use that readily available language. That was the only missing component part from the entire process. So that is what made the process itself flawed. Nothing
Okay.
else, nothing dealing with the specs, nothing dealing with notice requirements, nothing dealing with timelines. It was literally just that specific provision.
So you're saying that the motion adopted by the council to rebid this project is a properly passed motion?
That is correct.
Require that the new bid specs just be amended or changed to add that language that states about the funds?
That is
What
correct.
you're
And if
stating.
I'm not mistaken, it would be actually the advertisement, not necessarily the specs. but-
Right, the advertisement.
Yes, ma'am.
Okay, and so just for clarity, because, right, looking at the opinion, it does say that the bid law, it says Louisiana public bid law is not proper solicitation method.
Correct, and we would stand by that. However, as Ms. Rowbottom has already explained, the LDEQ approved that method. It's an LDEQ loan, so if they're fine with that specific solicitation method being used for their loan monies,
Right, and if
then
the council chooses, I guess, to use
to do
that.
something else
So-
or to do that, then it's fine.
Okay, okay.
I'm sorry, but had we been consulted, let's say in the beginning, we would not have advised use of the public
Right.
bid law.
For the, and not that it would have been that way, but I always felt like the meters, right, should be maybe a hard bid and maybe not software, but that's here nor there. But as it
Correct.
stands, well, just to catch it all back up, as it stands, the council authorized the project to be rebid. Would it be your recommendation, now that we have these, saw an injunction filed, some exceptions, some interventions on behalf of Green Up Industries. What would be the district attorney's recommendation to the council at this point, given that we do have these interventions filed, the injunctions filed, and all of these items? Would it be appropriate? I mean, technically, we don't have to take any action because the council took action to reauthorize this process. So at this point, there's nothing really that we should be required to do, but would the district attorney's office recommend, in light of all of this, to let this play out before administration moves forward with re-advertising this project?
Actually, we wouldn't even make a recommendation with respect to that. We would just advise the council that the council's under no specific order to refrain from doing anything. And so whatever the council would feel is appropriate action to take or no action to take, I mean, that would definitely be within the purview of the council.
And so what would happen, again, if we take no action, the action that was already passed by the council is live, it's duly passed. If the administration would move forward with that solicitation process and something comes out of these court dates that say this was done wrong, it doesn't, the courts don't rule in our favor, will we have to undo the process that they would have already started over? Let's say if they started it right now, and then 2 weeks later, the court says, no, that wasn't done properly.
If the court said that no, that it wasn't done properly, whatever ruling the court would hand down at that time, then the council would just be required to comply with that ruling, whatever it is. So if that ruling were to, start over or start from this particular point, well, whatever point the council was in at the moment or at the time that that ruling was handed down, they would have to just stop where you are and then comply with that and move forward from there.
Do you think it would make more sense to wait for that to happen from a legal perspective, or?
From a legal perspective, not necessarily, because the way we would look at this is basically, if the council feels as though it needs to act, then what we're saying is there's nothing preventing or there's nothing restricting or prohibiting the council from acting. If the council should act in such a way and, let's say, a ruling is handed down that would require the council to, I guess you could say, switch gears, then we would, advise you all of such and give you some recommendations on, how best to switch those gears.
So I guess the only reason why we're here today is because the council acted whenever that motion was passed. I can't remember if it was the last meeting, the meeting before, and nothing has happened. So we don't need to act again to solidify or state again we want to do that. I guess the ultimate question is, why hasn't administration moved forward with it? I believe that's what he's asking. Is,
Hang on one second.
and
I want to make sure that I get my answer on the
I want to turn your
record.
microphone on.
Okay. We did not, this statement is very clear. Okay, it's not about an option or I'd recommend an alternate, that wasn't the issue. There's alternates to do everything. That doesn't make it illegal. This opinion specifically says that this solicitation method was incorrect. Okay, now, of course, a lot of what was said in here is not valid. And again, we're going to rely on DEQ for saying that bidding the process was allowable, but we're not going to rely on DEQ who said the process was complied with, the advertisement's not required, your money's readily available, and we concur with this recommendation.
well, let me ask you this, though. If you're standing behind the bid process.
I'm not standing behind anything, it's
Or what-
conflictual.
Or what DEQ said that you could do a bid process.
Right.
And the district attorney's office is stating that if that's the method that the engineers have chosen, that's the method that this council has instructed to move forward, then to me, it seems like that you administration should be willing to move forward because the council is actually authorizing you once again to move forward with the process that the engineer said that y'all
That's
should be
correct.
using from the beginning.
And Ms. Hotard, you're correct. So what we did was we went back to LDEQ. Again, so we would have to submit to them an advertisement edition saying the money's not available, that they're telling us is not true. Okay, so that's where the holdup is. So the information in this opinion is flawed. So when, again, go remedy what? There's nothing to remedy. And again, none of the recommendations are being followed. Do we have authority to borrow the $6 million? Obviously, we had it, but that's your recommendation, that y'all need to duly adopt an ordinance. Okay, so how much of it is accurate? And we're contending, after discussing with all the people, at least 3 engineers, even Chuck, your parish engineer, reviewed it and said he concurred with the recommendation. So the consulting engineer, the parish engineer, the engineer at LDEQ, the bond attorneys insist that your money is, they were here last week to meet with us, we went over it again. We have done this repeatedly. Your money is readily available. It's a pay app. You just submit an application. As the project progresses, you draw down your funds. So there's not any, it's our money. We have up to $6 million that we can request down. Now, if we go over that, we have a problem. But they review the specifications of the project to make sure they're consistent with smart meter technology or whatever, but they're not overseeing our project. They're not going to be able to tell us, oh, no, they didn't do it, because they're not overseeing our project. When we get an invoice during the project, we review it to make sure that it's accurate, and we submit a pay app. But that takes place at the parish level. And then they respond to the pay app once you submit it, with the dollar amount that you're requesting. So,
But again, if we would have started this over 30 days ago when the council offered the motion, we'd be 30 more days into the process.
if y'all wouldn't have voted before you got the opinion, you'd have known that the
And I didn't vote.
solicitation, you didn't. But the solicitation, the opinion that came out the next day said it was the wrong solicitation.
And let's,
And I questioned that in my response, and the response was, we stick by our opinion. So, even though the majority of it was negated with documents and approvals, they stuck with this opinion, which says, number 7, installation of water meters is not construction, which is false, and the Louisiana Public Bid Law is not the proper solicitation method. So that's why we stopped.
and so now, since we've got it all clear that the duly passed motion of the council is a proper motion, what is stopping administration from putting this
Well,
project?
then we got the lawsuit.
But what legal is stating is that the lawsuit and all of the interventions and everything else that has been filed, it's not preventing anything from taking place. Because this lawsuit, let's say it's not resolved in 30 days or 60 days. There was a hearing that got pushed back. And so the more that we delay, it's more that it's just more time that the project is going to be delayed.
That's correct.
And I can, maybe sharing some of the feelings of it, even though it wasn't, a motion that I approved, it still was something that the council acted, and that's the direction that they want to go in. So at that point, I have to stand by, if you will, or, go with that.
Okay,
So
is everybody acknowledging that the opinion conflicts with your motion? Which came the next day. Can we get the acknowledgement that you made a motion to bid, and the opinion as completed the next day says that is the incorrect solicitation?
And if there is
Okay, but at that point, is
and I'm
that-
going
is
to
that
answer you.
correct?
I didn't make the motion,
I
but
know
if
you
there is
didn't.
an acknowledgement that the motion conflicts with the opinion, are you all going to start the bid process and follow the motion, whether it conflicts or not? Because that's not
Yes.
really the issue. Getting
Yes.
the project
We
to
actually
move
have it on the
forward.
agenda to amend the contract, to redo the bid phase with the engineer that did it the first time. So yes, that is on your council agenda for Tuesday. Now, keep in mind, as I said, every step is going to have to be approved by DEQ as we go along. So any changes we make, any recommends, so we'll just start the process again. It's something we're used to, and you guys know when we bring things to you. We ask for authorization, either pending approval of LDEQ or DEQ's already approved it, so that is the process. But keep in mind, and I fully understand what you're saying, you're right, this project is stalled for no good reason. But This council held up the project from April, whatever, for 5 weeks, based on a letter, the night of the council meeting, that was proved incorrect the next day. The only question you guys had, and the reason you stopped, was there was some question about whether the green-up bid was non-responsive, which it was determined to be, and 2, whether they were required to have a hearing, and they were not. So that was the first, and that took 5 weeks. From the time we made our initial recommendation, it was 5 weeks before we got an opinion. So again, you know, there's some lapses in time. They're just not all related to us. But on the agenda for Tuesday is a motion to amend the contract to do the bid phase over.
So we don't need to take any action today?
No.
And it's going to get moving as the council approved a month ago?
Yes.
So that's it?
I'm glad you two got understanding of it. Now, you let us get some understanding of it. Put this thing on, please.
Yeah, hang on, okay. Mr. Snyder, go ahead.
Oh, thank you, sir. You know, as far, I'm reading page 5, section B, and it states exactly what our district attorney says, and that's our reason for this. And it says we should advertise it that is not readily available. That makes sense. Okay, so that's exactly what it says, and it's in there. I guess it's part of the public bid law. And underneath there, it tells us, well, we didn't have to do that. I haven't read all of that yet. But if with what the district attorney told us earlier, that we could be, an injunction could be put against us if we do it without this part of it in there, without putting in there that the funds are not readily available. Now, Ms. Robottom told us a little while ago that we got a letter the next day saying that the process was wrong. That meant the bids was wrong.
No,
We
it
shouldn't
meant the
have used the
process.
bids. We shouldn't have used that. We should have used something else, which would have been proposals, I imagine. Right. So that part of it had nothing to do with this, because evidently you guys made the decision to go with a bid for some. Well, y'all the one to take care of daily activities. You brought it to us. We'll go off for bids. We say yes. Let's go off for bids. Not to go off for proposals. Okay. So that next day.
That's correct. That was 2 years ago.
Hang on, yeah.
I understand that. But you told me we got a letter last week saying something was flawed. No, nothing flawed. That right after we made the motion, then the next day you got an opinion saying that we used the wrong process.
That's the opinion from the district attorney's office.
Well, okay then. So that's the one we need to go by. To me, if they say we shouldn't put the bids out, then we don't put the bids out. Now, if they say we should have used a proposal, but since we used the bid, we can use the bid also, and we can go put the bids back out. That's what my understanding of it. Because I know Ms. Godet, she was pushing for us to use the proposal months ago. I understand that? Let's use the proposal that give us more flexibility.
It was a combination.
Well, whatever it was, I know you were supporting that part of it, because you voted against the bid part. All right, so that's what I'm saying. So our opinion here right now, guys, is if the district attorney say, no, we can't do this, then what we did when voting on going off a bid is mute. We don't do it. I know that. That's what I heard him just say we could do it. But now you tell me something else came out the next day. He said we couldn't do it. He said that. But you see, that's why I'm talking to these people up here need to understand exactly what's going on here. Maybe I don't understand and they all do. But not that they're saying we can't do it. You're saying something came out the next day, said we shouldn't have did that.
Mrs. Snyder, can I answer that? And I think I'm kind of following you, and hopefully you are too. You guys made a motion based on some preliminary information that said rebid the project. The next day, the same people who recommended to you
Right.
to rebid the project wrote an opinion and said bidding is the wrong solicitation.
What that meant?
That meant we should not have used the bid process for
What
this
process we should
project.
have used then?
Well, they don't have anything, but they didn't say, but we should not have used the bid process.
I mean, what other process we have we could have used?
An RFP process,
Request for proposals.
right. Yeah, either one of those.
RFQ would just give us qualifications. Proposal would have had to give us some numbers.
Right.
So that's where we're at right now. So we can't use that part of it. Sure, we should have used the RFP, but that's been passed. That didn't hurt us.
Right.
It hurting us now because we're saying we had someone that wasn't responsive, you know, and the responsive people you're saying was the highest bidder. So that's where our dilemma came in at now. But if we can go out for another bid, and that's what we did last week, then that's what we got to make a decision here right now. And you done told us you're not going to do it.
I didn't say that. I did not say that.
You implied it.
Mr. Mallett, can I address one other thing?
Yeah, please, go ahead.
I answered his question, okay, which was, we had a conflicting opinion with the motion that was passed. We also did not get approval from the authority that is required to authorize our actions to say that our bid process was flawed and that we needed an advertisement. We went back to the entity that approves every step of the way. They are sticking to their recommendation and concurrence. But with regard to the two projects, I think you said something about, well, one was non-responsive and the other one was within budget and responsive and responsible. The issues identified in the opinion, which said they were not licensed, was incorrect. They had a license since March of 2016. The other issue that was referenced to suggest their bid was non-responsive was in documents that were not part of the bid package. And we determined the responsiveness and the responsibility of the bid based on the bid package, which is in the bid law. That is all you can use to determine that is the forms that they require. There are only certain forms that you can require in the bidding, and utilizing those forms, the second company, one, satisfied all of the bid specs. Their bid was under the $6 million budget, thus we made the recommendation. And so I think you said something about the firm was the highest. Yes, it was higher, but it was still lower than the budget allowed for, which was $6 million. So I just wanted to make sure you guys understood. We can't throw it out because it was higher than the other one, as long as it remained below the amount of money we had available, which was $6 million, and it met all the requirements identified in the specs, and that is the case. And the couple of items that were referenced as to why they wouldn't have been responsive were false.
And I got one other question.
No, go ahead, Mr. Snyder, you're
Yes.
still up.
So if we were to move to redo this bid, what, as far as the specs are concerned, that's all right. That's what we're saying. All we have to do is we'd have to make it known that through advertisement, I guess, that the funds are not readily available. Am I right here? Somebody? That's it. And what that has to do with the engineering firm, because they're the one that got to rewrite just that advertisement? Is that a
No, they have to
it's a
manage-
rebid process? I don't quite understand all of that.
Actually, there's like 5 steps in the bidding phase of a project that was in their original contract, so we're starting from scratch. So
From
that-
scratch, what you mean? What the
from the
5
bidding,
phases are? What the 5
bidding
phases are?
phase.
What the 5 phases are?
Did I bring that? Hang on.
In the meantime, Mr. Green,
I can
you were
read
going to answer Mr. Snyder's question?
Yes, Mr. Snyder, you're absolutely correct. The only thing that would need to be changed, if you will, with respect to the bid would be the advertisement to include the language from 382215D.
It's probably about a paragraph or so? Or we got to do the
one
whole
sentence.
advertisement again? Okay.
So that would essentially be a cut and paste.
more or
Yes,
less.
sir.
That's what I
That's what
was
it
thinking.
seems like. And I know the project was re-advertised once before, in February, I want to say.
Project, right?
Yes, sir.
That's what I'm talking about, because I did see where it was done, because I thought maybe that was the reason for we had this problem with the bid form, because it was,
No, sir.
I don't know, I'm just, that's
No,
just my thinking.
I'll tell you what
Something
happened. We
outside of
didn't
my
conclude the
comfort.
process. We did not conclude the process and get to this point.
Yeah.
Before we did, there's a pre-bid meeting that was mandatory. And in the dates in the newspaper, the pre-bid meeting was before the last advertisement. So before we accepted anybody's bids, we issued an addendum, which is also part of the bid law, that says, look, disregard that we're going to advertise this for 3 more times to make sure that everyone has the opportunity to see the advertisement 3 times before we move to our pre-bid. So that doesn't really, it didn't conclude like it did at this point. We concluded the process, we accepted all the bids, they were assessed, they were, all the documents, they did all the work associated with evaluating bids, and then we got to this point. Whereas the last time, before we got to this point, an addenda was issued, which is valid and lawful, that extended the bid to a later date. Because it was originally, I think, gonna end in March, and it went until April.
Yeah, hang on one second, ma'am. Did she answer your question?
Well, no, not really. She answered my question more or less,
Okay.
but it still got some clogs up there in that, I like to look at things simply and look at things logically, okay? And when I looked at this, and the bid that was turned in, the sheet that was turned in, well, the sheet has some markings on it and some changes on it, okay, from green up, I think, if I'm not mistaken. But they read that from cubic yard to square feet, which is the same thing, and you can do that, if you know how the conversion go. Now, but because they marked on it, what I'm saying is that was it possible that when we put the first bid out, that they did their homework, and when the second bid came out, it was already, because it had been advertised, it was already out there, it was already on our site. Am I right? And the site, and the bidding site. So it just, did that cause any confusion? And that's what was stuck in my head for a long while back then.
And we thought
Did
so.
that cause any confusion? That's why we got what we got.
Actually, we would have thought that if they hadn't attended the pre-bid meeting. They signed in at the pre-bid meeting after that first set of advertisements that said, use another set of forms, answered all the questions relative to, how when there are questions from the bidders, you have to provide the answers to everyone. There was a document provided at that meeting, that pre-bid meeting, that covered all those things. And there were at least 2 people from that firm that attended that meeting. So if maybe they hadn't attended the meeting, I would say maybe they got confused with the first bid, but they actually attended the pre-bid meeting where all of those things were covered.
But the pre-bid meeting was after they had the homework, in other words. That's after they had the bids out, or had the bids prepared, or whatever. That's all I'm asking. Because that was kind of further in my head.
It could have been, especially since they referenced the wrong addenda from February instead of the April one. But there were numerous things wrong with that bid. The mere fact that they added 5 items, even if we'd have discounted all those others where they changed things in the bids that we requested, which we couldn't have discounted it, but let's say we did. They added 5 new items to the bid sheet that were not in our bid. So again, all of those are violations of the bid law. So yes, what you referenced was a problem, but there were numerous problems with the bid.
All right.
Yes, ma'am.
If
Go
I'm
ahead.
not mistaken, I thought the DA's office pretty much stated the fact that Green Up Industries' proposal was non-responsive, even though they reference
Well, like I said, I'm
Turkito
not,
also, but they did reference Green Up in that
I'm not saying
opinion.
it's not. I'm not saying they didn't do that. All I think I'm saying is that it was a sore spot with me, and I wanted to make sure that cleared up
Yes, sir.
You know, because I keep going back to that up here, when I look at all of this, did we cause some of that? And what you're saying, no, we didn't cause some of that, so I'm,
No,
you know,
no.
I don't have a problem
There's a
with that.
process, that's the whole purpose of an addendum, that contractors have an opportunity to ask whatever questions, and then we publish, as the parish president stated, so that all the other contractors who are bidding on that project can see what other individuals are asking. So they had more than enough opportunity to address whatever concerns or questions that they may have had. But I have a question for you all in regards to readily available funds. If DEQ is stating the fact that, and again, DEQ is no different than FEMA or CDBG or any proposal that you write, they do not deposit the money in the account. There's a process that we have to go through. So DEQ is no different than the funds that we receive from FEMA, which is the $2.4 million for the elevation project. We still have to go through that, which is a requisition or request for funds. So it's still, even though we were awarded the funds aren't in the bank, however, but they're readily available for us to move forward on the project. So it's the same scenario. It is. It's the same scenario. It's no different than any of our other projects that we're doing or that we've done. It's the same process. You write a proposal, you get awarded the funds, and then once we know that we have the funds and that we have been awarded those funds, then we have access to those funds by requesting when we do what we call reimbursement. So we submit when the work has been done, and we get reimbursed for the work that has been done. But in this case, it's a loan. So it's no different than we have a loan, it's ready available, but let's just suppose that we put that language in that document, and DEQ states the fact that that's not necessary, because pretty much that's what they're saying, is that the funds are there.
OCD did the same thing to us. OCD did the same thing to us.
No, those are separate
Well,
projects.
Okay. then.
Yeah, I know
This is
LeBron
process.
referenced it.
Hang on. We got the money there. They say, okay, you approve for this
Yeah,
$30
no,
million.
that was a bad example.
Can I finish?
Yeah.
That wasn't a good example.
We got $30 million there. And we still had to go through a process. And we did everything they told us to do. And then at times, we went to get money. So, well, no, we changed something. Something got to be done this way. So we held up a lot of contractors. Some of them went out of business because we held the money up so long. Because of that. Because the money wasn't readily available. If that money had been readily available to those contractors, to us, then we would have paid those contractors. We might have had to get them back in here, but we would have paid those contractors. And they may not be out of business right now.
Well, I stand to be corrected in regards to that.
Yes, ma'am.
And I just would like to clear up, those are two separate projects. Right, OCD and FEMA are different
I'm talking
projects.
about readily available. I know there were two different projects.
I know, but you
I'm
used that
talking about
example.
readily available.
Okay, readily available. The example that they gave us for when your funds are not readily available, there are instances when you, for example, for the FFA, they won't let you close on your loan until you've bid your project and you know what your amount is, and then you close on that amount. Okay, that's when that advertisement is necessary, for you to tell them, you know, look, your funds aren't readily available, because once we get our bid number, now we have to go back and close on our loan. In the case of our projects, we closed on our loan in January. We closed on our loan in January, which at that point, on that day, those funds became readily available, which as government, we don't typically go out for bid if we don't have the money. I think it's a violation of the Budget Act. So that is why it takes so much time. So once we got the permission in December, move forward, we went to the closing on the loan. We had to pay the financial consultant, the bond attorney. We had to pay DEQ's attorney. That was our first payment at the loan closing. And then we waited for that before coming to you to bid out the project and then open the bids. Now, had we not closed on our loan and completed the process, then that advertisement would have been required. But because we already went through the funding process, you know, your bond attorneys, like, they put that language in those ordinances that you pass. And again, everybody is aware, for governments, we're not supposed to bid projects without the funds. So we couldn't have moved forward in the first place if our funds were not available. So if you think about every time we come before you and ask for permission, we tell you where those funds are. We tell you it's coming out of this, it's coming out of this, because we can't, by law, bid projects without having the funding available.
Quick question for you, Madam President.
Yes. We gotta
Is
go.
there a drop dead date that the funds from the low-interest loan have to be used, or the project has to be completed, that could possibly jeopardize the loan? Are we under the gun to complete anything?
Not to my knowledge. What would jeopardize the loan, and Rob may be able to answer,
Yeah.
is not following the process. And that's in their guidance. When you don't follow their processes and get their approvals along the process, then you're jeopardizing your funds.
Rob DeLon, Digital Engineering. The loan was closed in January, and there's a 2-year time frame that is expected for the project to be completed. If it is not completed within those 2 years, DEQ will send a letter requesting whether those funds will be spent within a timely manner, or they will basically pull the funds. So there's a 2-year window.
Okay, 2-year window as of January 2019.
Yes.
Okay, well, we certainly don't want to use that entire 2-year window. Mr. Green, in your opinion, sir, I think you said Greenup's non-responsive, but you also had some questions, or you had an opinion on Aquametrics?
Yes, sir. The district attorney's opinion actually said that both parties were non-responsive.
We're non-responsive.
Yes, sir.
Okay. Ms. Councilwoman Gode?
Thanks. And again, I think those questions about responsiveness were received, the opinion, but it still doesn't change the fact that the council authorized to start this process over a month ago. That's what we have to do. To your point, Ms. Toombs, I know you said that DEQ stated that it wasn't required to place this language in the bid specs, and it was also not required by the DEQ that we use a bid process. However, we elected to, one, use a bid process, although it wasn't required by DEQ, and two, we're also requiring to place that language in the bid specifications at the advice of our legal counsel. So the solution, again, is the council authorized the motion to rebid this project, including this language, whether it's required or not. It's not going to damage or nullify the bid specs. So again, we've got a motion. It was approved 30 days ago. We've heard from legal counsel that this project can be bid if the council chooses to do so, which they have. So then, if it's on the agenda for Tuesday, then we're moving forward with that. If the courts tell us to do something different, then at that time, upon the same advice from legal counsel, we'll do something different. But right now, the council doesn't have to take any action because the action has already been taken. And they have requested that that language be placed into the bid documents, whether or not it's required by DEQ, because our legal advisor is telling us to put it in there, and DEQ is not going to say that it's going to make your bids faulty. So to move this project forward, which I think is what we all would like to do, is that we follow the motion of the council, rebid the project, and get moving. We're already 30 days behind where we could have been had we have started it over when the council authorized the motion. So
Probably
there's
60 from,
maybe even
from April 28th.
yeah, maybe even 60. But where do we go from there? We can talk about who was responsive, who wasn't responsive. It still doesn't change the fact that the council authorized to start the process over at the advice of legal counsel, add this disclaimer into the bid specs and move forward. And we can talk about it until tomorrow, but we still need to start the process over and get moving because that's what the council instructed the administration, to do 30 days ago.
And I'm going to say it again.
And I
Have
think
the
you
opinion
haven't been
agreed with that?
recognized, nor will you be.
And
Hang on.
I'm not disagreeing.
Okay.
You know what I mean? At this point, we can all look back, and like my dad always says, that's why the rear view is smaller than the windshield, because we've got to look forward. And how do we move forward from that? It's funny,
Yeah.
he's been calling me. I said, Dad, I'm in a meeting. He doesn't understand it. He's older. He doesn't understand. I can't just answer. But anyway, I thought about what he said, and it's the truth. We have to move forward at this point. And if we would have put the bids back out with this language, we'd already be 30 days into the process. If the courts tell us something different, then we have to do that. But we can't sit on our hands and wait for the courts to decide. It could get delayed again, just like it was delayed Friday. More motions and things like that. All the while, we're holding up the process and trying to just throw the blame around. And that's not going to get us to move forward.
I think you're absolutely correct, and probably the only decision we could make today would be to order the administration to submit the bids by a specific date. Mr. Modair, thank you.
Ms. Hotel, go there. Appreciate everything you just said, because that's just what I was about ready to say. Okay, Mr. Green came to us, our legal advisor told us 30 days ago that it was a problem with the bid process, the bid law, and also something with each one of them was non-responsive. Okay, and at that time, the council did vote that we rebid the project and put everything in there that the DA office says should be in there. And administration chose to get into who's right, who's wrong. Okay, when the council made that motion to rebid, then administration should have went out and rebid the process just like we said. And anyone who objected to it that was involved have the right to file a lawsuit like we are in right now. And like Mr. Green said, if it came back that the person who filed a lawsuit was right, then we would just stop and do exactly what they said. Okay, now we can stop and do exactly what the judge tells us, but we didn't start and do the process that the council authorized you to do. And that was 30 days ago. That's the problem I see. Okay, council asked you to do something we should have started 30 days ago and let the legal action that anyone wanted to take against the council proceed. And if the ruling came back something different, then like Mr. Green said, we'd stop and do what we're supposed to do then. But it was clear cut what the council wishes was that 30 days ago. And we shouldn't be at this meeting today discussing what was ordered 30 days ago. And going over and over and over who's right, who's wrong. A motion was passed 30 days ago, and that's what should have taken place. And we should not be here discussing something that we discussed 30 days ago.
Thank you, sir. Mr. Saraparu.
Yes, and Mr. Modair, I really appreciate you saying what you said also, but I had a question for Rob. Since we're going to be picking our time with this, look like we're not in a real hurry to move, which I think we really do need to be moving. I have a question on the separation of the meters versus the labor. If we go out for bids on Monday morning, how long is it possible for you to separate? How long would it take you to separate, put a separate bid for the meters versus the labor? And is there advantage or disadvantage of doing it that way?
We would, okay, so what's on the council agenda for Tuesday is for funding for us to redo the bid phase, which is the exact amount of money that we were paid for doing the previous bid phase. We're not asking for any additional money for specifications or because that's not going to change. If we separate this out, then we have to go into the specifications and separate everything out for meters being bid and then doing an RFP for the software and the AMI. And that could take up to 60 days to get it finalized because we'll have to submit new specifications back to DEQ for bidding, and then we'll have to submit new RFP to DEQ for bidding, and they're going to have to review all of that and either provide comments or approve it. So I'm thinking around 60 to 90 days it would be delayed because of the required approvals and the work that would need to be done.
Okay, and I'm trying to make this a learning lesson because this has been a roller coaster ride for me. Is it a common practice to bid the meters separate from labor? Is that a common factor that happens? I understand it is. Where you sitting right now, is that done on a scale like that?
Normally, meters are bid individually on like annual contracts. So, once a meter system is in, yearly, the entity has to bid those out to get prices for replacement meters, of meters that are broken, or if there's like new developments that come in where you have to put in a new meter. That's normally when only individual meters are bid, is when you're doing maintenance type projects, or if you have like a big development coming in and you already have a meter system and you know you need a whole bunch of meters, like 500 or 1,000, bid them out so you can get those installed for the new development.
So if we give you approval to go out for bid on Tuesday, how long would it take to get that started?
We have to put that sentence in the advertisement, send it to DEQ. DEQ will probably take a week or so to turn that around, and then we can go ahead and advertise on the next advertisement date available through the La Observatoire.
Okay, and when the bids come in, we still have the right to reject all bids, correct?
Yes, that's correct.
Okay, thank you.
I didn't hear your last question.
The question I asked him.
Yes, sir. Yeah, I just didn't hear your last question.
When the bids come back, we still have the right to reject all the
Okay.
bids. Yes.
Now, must say, if you have grounds to reject those bids, so, for example, if the bids came in over budget, or if they were deemed non-responsive, or if there was something deemed wrong with the process, then yes.
Thank you.
I have a quick question for you. Who is the governing party that would typically, and I'm talking about a municipality, deem a bid non-responsive?
Usually, the engineer that's involved reviews the design engineer reviews the bids, and that's part of the bidding phase. You review the bids, tabulate the bids, see if all the documentation was submitted correctly. Also, make sure that all of the numbers add up correctly, and make a recommendation on whether that bid is responsive or not.
Okay, so that would have been you?
Yes.
Yes, sir. Okay, all right, thank you. Mr. Snyder?
Yes, Rob, Mr. Saraparu brought up the fact that we decide to put those out separately. I'm not going to say put those out separately. Will we still have to do a bid on the software and the AMI part of it?
You could either do a bid or you could do an RFP. That would be up to the council, but as I discussed, there would be more delay if we do that.
Yeah, that would be another 60, 90 days.
If we go through, do them separately?
Yes.
Okay.
So essentially, in order to continue on with this bid phase, it sounds like it's going to take you about an hour to change some language around, submit it to LDEQ. Is that true?
That's correct.
Well, I think right now, any other questions, comments? None.
That's a motion to adjourn. Motion to adjourn.
We do have an executive session.
Do we, Keith? I thought they said we did.
Yeah, I think the
Yeah,
executive
we
session
do.
says an update on the litigation.
Oh, yeah.
So we have, we have a motion to adjourn.
She pulled it because we
I
got.
can pull it if we
Yeah,
got.
because we got.
Okay, we have a pull it. So we can actually
Recess.
take a motion here
To do that.
to move the bid processing, or to have digital submit the documents to LDEQ by Monday to begin this bid process.
Well, did we do that okay already, 3 weeks ago?
What hasn't been done. So what we, so he doesn't have the funds to do that. Hang on, our board went blank.
No, we're okay.
There we go. So we don't have the money, he doesn't have the money to resubmit.
Or the authority. The contract that's currently in place, that portion of it has been expended and completed. So that's why we were on your agenda for Tuesday as an amendment to add the bidding phase, just amend the contract, add a second bidding phase for this project.
How much did that cost us before?
16,000, I think.
To rebid?
The whole process, yes.
The whole process cost us that? How about we had, didn't we put two bids out?
I'm sorry?
First one, did we had amendment or something like that?
Addendum,
Addendum?
Addendum.
Did
But
we
it-
do
but-
that? Well, how much did that cost us?
nothing. It was part of their
Well,
process.
how, why is it gonna cost us something?
Because they finished the entire process.
This is,
No, sir. This
Yeah,
is
this would be a new process.
a whole
well,
new,
well, no, not a whole process. I mean, at least I've got the process, but I don't know what
Yeah,
we're
'cause
talking about now.
I don't understand.
But we put a bid out before, right?
Yeah.
Yes, sir.
We put a bid out before, and then we send an addendum out
right.
to the same bid.
Yes, sir.
Okay, now we're sending another addendum out to
No,
the
we're
same
not,
bid.
we're not sending an addendum out.
Okay, then let's put us in the ballpark then.
Because it seems like $16,000 to change some dates and add, cut and paste.
Exactly.
Is a lot of money,
Exactly.
is a lot of money.
Let's go.
All right, so
Let's go.
Yes, sir.
I'd like to clarify what the bid phase is, and changing the advertisement and sending it to LDEQ, that, we're not asking for any money for that. That's part of the specifications that we put together,
Okay.
and that's a minor issue. The bid phase, the responsibilities of the engineer in the bid phase is to put together the agenda for the pre-bid meeting, conduct and hold the pre-bid meeting, do the pre-bid meeting minutes, send out addendums as required, answer any questions that are posed by prospective bidders, review all bids that are submitted, and there'll be all new bids submitted, go through all of them, it's going to be a lengthy bid, and based on what we've gone through, we need to go through it very thoroughly, make sure that everything's in order, make a bid recommendation, and do a bid tabulation. So that is, the whole process. So it's not just a matter of changing a sentence and, putting out one addendum. There's a lot more involved.
And that was in reference to changing the specs to LDEQ, not the entire bid process, because there's a lot of stuff that goes into that.
Right, exactly. So we're not,
So
we're just asking.
whether or not we can still submit the new specs to LDEQ and then move on the contract, or the new contract, the 16,000 or whatever it is that we're going to have to pay for this on Tuesday.
Yes,
And we would still be moving forward.
correct.
Okay. Mr.
Well, the only thing I have is that, I'm sorry, I'm recognized?
Yeah, go ahead.
Thank you. The only thing I have is that I saw on the agenda that we got to look at this contract, but we didn't have an amount there. We didn't have anything in there that is sent to us as far as what we are amending. They say we got to amend digital contract, and it's on for approval. Well, that's all it is, I don't know if it was $1 million or $1, and that's why I asked the question, what are they gonna cost us? And I would do the same thing Tuesday night.
You're right.
Except, so why can't we get that information? Why are we getting this vague information?
Mr. Snyder, you would have, of course, we're in a short week. That is what you usually get when you get the draft contract.
I know you're right. You're right, we
so
usually get that.
We were still working on that today to try and get it out.
Hold up, you tell me you're working on,
We know, we have that. We have the scope, we have the pricing. Is the half a page of stuff that we have issues with, that we usually have to send back and forth. So again, the pricing is identical to what it was. We pulled out only the bid phase, because that's all we're asking them to redo, and we're putting that in a document. So yes, we know what the price is, because it's the same thing it was last time.
$16,000?
Yes, sir. Wait, let me tell you exactly. 16,675. It's in the original pricing schedule, task 4 bidding phase, and that's 5% of the total project cost. Again, we don't usually put that on the agenda, but you get it in your draft contract document that describes everything that we're asking you to approve.
I mean, I don't know, I just think it's nice to put it in there, put it on the agenda. This is public money we playing with. The public need to know.
Does anybody have a motion?
Recess.
Want to go in the executive session?
Do we have to? Do we have to tonight? I mean, like we do.
The DA's office, and he said for, I guess, for administration to request if we could move this to Tuesday because of the time constraints.
I thought I saw that, and I was reading it. You wanted to move it to Tuesday, executive session?
It wasn't us, Your Honor. It wasn't us, Mr. Chairman.
Yeah, you get me confused, my father. That's okay.
But we would not have any objection to the
Tuesday.
council, to Tuesday, no, sir,
Okay.
not at
All right, good. Thank you very much, sir. We have a second motion. We have a motion by Julie. Let me say this. This is, just to cut you off for a second, sir, and madam. What we've been talking about here is a $6 million contract, and there's a lot of concern. And for anyone's sensitivities to have to come in and spend a little extra time to conduct the parish's business, well, my apologies. We have a motion on the floor to adjourn from Ms. Remenday, second by Mr. Snyder. Go ahead and vote. And that passes. We got everybody voted. That's gonna pass 5 yea, 3 absent, and 6 yeas. Okay, Mr. Montero is 6 yeas, 3 absents. Thank you. We'll see you Monday, Tuesday.
We don't mind doing it. We had a problem doing it today. Okay, because we spent a lot of time on this, and the only thing was we knew what our schedule was like today, and to not actually know until yesterday that we would have to do this in the evening. That's